Point. And we are back to, I'm sorry, we are back on page 311. Thank you. Roseanne, discussion and possible recommendations regarding practice setting definitions.
Yes, so this proposal that you're going to consider now is part of the work of the Exempt Setting Committee. The Exempt Setting Committee was formed by the board for two purposes. The first one resulted in AB 630, that was to examine mental health services provided in exempt settings to determine if consumers are receiving services consistent with the standard of care for mental health professions. And then the second reason was to examine different types of practice setting definitions that offer mental health services to determine if setting definitions need to be refined. There was a lot of confusion about where, especially associates and trainees, can and cannot work. So the committee spent a lot of time surveying and discussing that. The committee completed its first objective with AB 630, although we're going to be discussing parts of that bill in future policy committee meetings, as we discussed earlier. And now the second part of that the objective we're going to tackle today, which is clarifying practice setting definitions. And so proposed language related to this objective can be found in attachment A, B, and C for LMFTs, LPCCs, and LCSWs respectively. So the proposal provides specific definitions for the various types of practice settings. It clarifies all settings into two main types: exempt settings and non-exempt settings. The definition of exempt setting remains the same. Non-exempt setting is all settings that do not qualify as exempt settings. And then from there, we split it out a little bit more specifically. We carve out two specific types of non-exempt settings, which are private practices and professional corporations. And then we use those definitions to place certain further limitations on these specific types of settings. The proposal reiterates that an individual working in an exempt setting who holds a board-issued license or registration is still under the jurisdiction of the board. And it reiterates that an active or license or registration number is required to provide psychotherapeutic services in any non-exempt setting, but with two exceptions. A trainee may provide services in a non-exempt setting as long as it's not a private practice or professional corporation. And then an applicant for associate registration following the 90-day rule can do the same as long as, again, it's not a private practice or professional corporation. And that should clear up some of the confusion that we had. We had received a lot of feedback about, there was a lot of confusion about where trainees could work. So the next thing is the proposal limits supervisors in any non-exempt setting to 6 individual or triadic supervisees at any one time. Previously, the limit was 3 associates per supervisor, and the limit was only for private practices or professional corporations. So now it's going to be at any non-exempt setting. And it also permits contracted supervisors in private practice or professional corporation if the supervisor is providing psychotherapeutic services to the clients at the same site as the associate. So that's new. Previously, there was no contracting for supervisors in private practices or professional corporations. And then we are also tackling one difference in LPCC proposed language. We're renumbering a section and making a change. It talks about the training of graduate students as LPCC trainees under school supervision. It talks about how trainees can work in various settings if they are pursuing a degree toward LPCC licensure or if they're working in a recognized training program. We dealt with this with LCSWs last year. There's no recognized training program. That doesn't really mean anything. It kind of implies that a private practice might be okay, which is not the case. We amended that language for LCSWs last year via AB 630. So we would like to do the same for LPCCs in this bill because that section came to our attention. And we also added an amendment to reiterate that trainees cannot provide services in a private practice or professional corporation. So the language was developed by the Exempt Setting Committee and was considered and modified by the Policy and Advocacy Committee. There's some major changes that was made after Policy and Advocacy per their suggestion are shown in red. Other amendments are shown, I think it's in blue or green. And then at the August Policy Committee meeting, the committee recommended that the board consider this language as a legislative proposal. There's one further item for consideration that I want to discuss as part of the discussion, so I don't know if you want me to do that now, or we want to start the discussion and I can throw that in there later. Just do it right now? Okay. So on page 322, one of the things I just want to double make sure that we all are on the same page as, page 322, section 4980.43.4, subsection B, where we are talking about an associate who is employed by or volunteering in a private practice or professional association must be supervised by an individual who is employed by or contracted or is an owner, and who also provides psychotherapeutic services to clients at the same site. I wanted to make sure that we didn't want to, that we only wanted to have that requirement in private practice or professional corporations and not in non-exempt settings in general. Currently, the limitation is only private practices and professional corporations, and I think that's fine. But we did decide to limit the number of supervisees per supervisor. Previously, that was only limited in private practice and professional corporations, and we decided at the P&A committee to make it all exempt settings. So I just wanted to make sure non-exempt settings. I wanted to make sure that we were not missing anything.
So I would want to ask the P&A committee, what are the other kinds of non-exempt settings that aren't private practices or professional corporations? Say that 10 times fast.
I think, but based on the definition, the private practice and professional corporations are the only two exempt entities, not under.
Non-exempt.
Non-exempt,
Yeah,
yeah,
non-exempt, yeah.
So, but
Oh, Christie.
So there are other types of, so if any for-profit, basically. So you could have a general stock corporation, you could have something that's owned by an individual, like a substance abuse treatment facility, something like that.
then I think I'd want the all non-exempt, not just private practice and professional corporations. That's where I'm leaning.
That's what it kind of seemed to me when it raised a red flag when I was reading through the language after the committee that, I don't know, it could pose I know that some bigger companies have supervisors that travel around and that's how they do it, but it just kind of seems strange to me that we would require the supervisor to have be performing psychotherapy in a private practice, but a big corporation could potentially just be sending a supervisor around from site to site. So something to think about. I know we don't want to create any major unintended consequences.
But none of those people are here.
But yeah, I mean, maybe we could ask the stakeholders to go back and think about it, and we could make a change and discuss it later. But I just wanted to have it. I think we kind of focused last time on the number of supervisees, and I think that piece kind of just didn't get discussed as much as maybe it should.
I'm a little, there's something about that language, and especially if we attack it without really looking at the implications, that worries me a little bit, because we're looking at it through one lens.
Mm-hmm.
And it seems like in the past when we've done that, there've been all these other little areas that we end up having some unintended consequence, and the last thing we want to do is make it so that we're limiting in any way mental health services. I mean, we've already heard that that's, huge. So I kind of almost like us to think about this one and get a little bit more information, make sure that there are no unintended consequences. What are the rest of the board's feelings on that?
If there's a way to do that doesn't hold up the process, I think that probably would be the most judicious direction.
I would recommend leaving it as is and approving the language, and then we could discuss it a little bit further at P&A. This would already be a bill then, but then we could always do an amendment if it was felt that was needed.
Okay. I have several questions. Okay,
Are we, let me make sure that we're at the end of This, are we at the end of this section? Okay, then let's go ahead and open it up for board comment.
So for the things that you have listed, I actually don't have comments on that, but because of the new supervision language, I was reading through all of this more carefully. And so on page 319, under item B as in boy 3, let me know when you're there. Okay. The last sentence says, "A supervisor shall ensure that the amount and degree of supervision is appropriate." For the supervision bill, we used extent, quality, and kind of supervision, and I wondered if we wanted to change the language now in all three areas, all three licenses, to match the supervision bill.
I'm not sure that that section's already in law, so
I
you
know.
would be revising it. Is that what you want to do?
Yes.
Okay.
I just thought since
Just for
we're
clarity.
here, since we're changing the other stuff, it's the meaning feels more precise as extent, quality, and kind, as opposed to amount and degree. I don't know. It just stood out to me for whatever reason that we had changed that in the supervision bill, and then it seemed like it would fit here too,
I'm wondering, are you referencing to some particular section that is, the language is inconsistent, or?
yes, yeah. So the new supervision bill says extent, quality, and kind. The supervisor is responsible for the extent, quality, and kind of supervision. And so this is the old language. Just for consistency.
So I think, Roseanne probably will need to do a little
Research on that.
cross-comparison to see which part of the languages is still referred to this versus what Leah said, right?
So what I recall is that this is specific to just group supervision, and this language was added just to make sure that every person in group supervision, because it's 8 people,
Right,
was getting enough.
right.
And so I don't know that it's extent, kind, and quality is quite the same thing. I
So-
could be wrong.
I'm looking in the statutes and regs book, in 4980.43.1, under the, it's basically defining what supervision is for all supervisors, and the first thing on the list is ensuring the extent, kind, and quality of counseling performed is consistent with the education, training, and experience of the supervisee. So that's one of their overarching responsibilities.
Okay.
So
No need to
it's-
change it here.
It's, either way, I mean, it's still covered. The focus of that, the purpose of the sentence in the language we're considering today is a little more targeted toward group supervisees. But it's not, I mean, if you wanted to change it to extent, kind, and quality, it's not a deal breaker either way.
I'm a group supervisor, so I actually think that the amount and degree of supervision is more appropriate than the kind and the,
Well, kind meaning group versus individual, like maybe
Right,
they shouldn't be in
exactly.
group supervision,
but
maybe
then
they
when
need to
they,
go back
yeah,
to
when they
individual.
when they're, for this one, it's about in the group, that they get the equal amount or whatever the amount, the attention, the interaction.
Okay.
So I think this is actually a lot more appropriate in
Okay.
terms of the group.
Okay, that's
That's my
fine.
opinion.
And then I had one other question. I'm not attached to it, I just wondered. On page 329, and this is relevant for the LPCC, under 329, under the direct supervisor contact, A, number 2, and at the end, last sentence, it says, "No more than 6 hours of supervision, whether individual, triadic, or group, shall be credited toward any single week." I was thinking that the pre-degree hour, maybe, never mind, I just figured it out. Never mind.
You talk yourself out.
Well, no, it's just because it's not regulated in the same way as MFTs are regulated, and I was like, oh, does that need to be in here? But yes, it does, so never mind. Thank you. Sometimes I read things and I'm like, oh, I'm really clear, and then sometimes today, or whenever I read this, I apparently wasn't. No, this was like a week ago. I can't use lunch as an
Okay,
excuse.
any more comment from the board on this section?
Yep, there's
Okay.
that.
public.
I just have a clarifying question. Roseanne, just to make sure I'm reading it correctly, page 322, with respect to an associate in a private practice or a professional corporation, presently, the supervisor has to be employed by, and if it's a corporation and practice full-time, and the proposed new language is actually more flexible, it's
Yes.
saying employed or contracted, and the
Yes.
full-time is deleted. I'm getting that correct?
You are correct.
I like that.
Yeah.
I mean, the only other comment, I was talking with Ben about this at lunch, the respect to changing the, allowing in a non-exempt setting, a maximum of 6 supervisees. It's hard to know how to feel about that exactly, because I think a lot of our members would be upset with me if I said that I wasn't crazy about the idea because they want to do it. But I'm so used to talking with people who struggle supervising already that I'm worried about competency and oversight in private practice settings. So I appreciate the intent to make it, to give more opportunities for people in private practice settings, but the other part of me is worried about oversight. So for what it's worth, just sharing that thought. Thank you.
What Mike said.
No. You know, as I recall, I think we had some really extensive conversations about this. I think we had, wasn't it a meeting in Southern California where this really came up? And we had a lot of public input and a lot of representation. And at the end of the day, the feeling was it would be a good thing. And Jan Lee's nodding his head. I just remember that meeting as being like tons of stakeholder input. And I think the feeling was that there are people who would really, it would ease some of the challenges that people are having in terms of trying to get adequate supervision. And
That was my recollection.
Christina?
I also want to bring up another point is because when we, with a new law, it allows a triadic supervisor. So when it becomes individual supervision means, 1 to 2, then it only makes sense to double it up to make it 6. Does it make sense? So I think that was one of the
That was one of the
perspective.
points that were made, is
Yeah,
that
so that's
with the
relevant.
triadic supervision, it
Yes.
would be much easier instead of,
Yeah, so.
to provide quality supervision to more people.
Right. So, and I think the other thing that we worked on, with Leah's, supervision bill is that I think there's a lot more mechanism. Leah's bill, sorry. It's really not Leah's bill. It's our bill, but it's the supervision bill. That I think there's a lot more mechanism put in place to monitor the quality of the supervisor and the supervision and all that. And so, I mean, this is a good concern because we want to, we want the licensees or the registrants or trainees to get the quality supervision, but at the same time, so that we address the concern, we're working on it. So we're just waiting for the time pass to, to get those bill going.
And there are random supervisor audits that will be coming.
So between the added requirements for training, oversight, we also had the conversation that this is a maximum. So certainly if a supervisor feels like they are only able to supervise one person, 2 people, 3 people, the way the new regs are written, it really puts that onus back on the supervisor to take personal responsibility for providing high-quality supervision. And if they can only do that with a limited number of people, that would be the expectation. The ethical expectation would be that would be what they would provide. Is that right? Deborah?
Add where credit is due, and I believe it was your colleague Mary, that is the one in Southern California, that brought up this issue put forward this solution. This was not our solution. This was, what's Mary's last name? Dr. Reed's from CSU Fullerton, correct? She deserves the credit for this, and that's why I want her name on the record. And she came forward, and it was, we discussed it, and so it was the input from the organization that came forward, and it was non-debatable. It's just something, different eyes see different things, and it just made sense when she laid it out, and we went forward. But I just wanted to give her credit because she's the one
Thanks,
that
Deborah. Yeah.
was the brainchild behind making that proposal.
Yeah. Okay,
Is it time for a motion?
I believe unless there's additional public comment, I think we are going to go back to the board for a motion.
I can make a motion. To direct staff to make any discussed changes and non-substantive changes and to pursue as a legislative proposal.
I'll second that.
Deborah Brown,
Yes.
Christina Wong,
Yes.
Dr. Leah Brew,
Yes.
Max Disposti.
Yes.
Betty Conley.
Yes.
Jonathan Maddox.
Yes.
Crystal Anthony.
Yes.
Motion carries.
And just as an aside, I will, so no changes to the language right now, but I will bring that one piece that we talked about at the beginning to P&A in February for further discussion.
Like 343. I was liking that. Page 343.
49.
Oh,
Oh, that's Kim skipping, sorry.
sorry.
I am.
Apparently. Okay, so correction, 349.
No.
No?
3, you were correct, I was
Oh.
wrong.
343. All right, Christie with the discussion and possible action on examination rescoring application abandonment and APCC application fee.
Thank you. Yes, so this is a regulatory proposal that the board had already approved, and we had already sent through the initial review process, and we had noticed it to the public. But what happened was agency had requested some very minor changes in the language. We went forward with it thinking they were non-substantive, but when it got to OAL, they felt they were substantive. They're very technical, minor, so what we're having to do is just bring it back to you for another okay. So on the topic of examination rescoring, what we're changing is that, so just to tell you what the reg is doing as a refresher, we have a fee for exam rescoring, but that process is not defined. So what we're saying, because all of our exams are electronic, unless you have an accommodation, we are only going to rescore paper and pencil exams, because otherwise it's on the computer and, there's no point. It's a wasted fee for people. So what agency asked is that they wanted us to put in the law, or we had said in the original law that we wanted a brief explanation of why the candidate is requesting rescoring. They asked us to just say, change that to say that the request must be made in writing. So that's the one little change there. And then, so then the next piece of this reg package is on application abandonment criteria. Our current regs specify the circumstances under which an application is considered abandoned by the applicant and describes the repercussions of abandonment. And so this proposal is just streamlining the criteria and making some technical changes. And what agency requested really is non-substantive. The language has, attachment A has the proposed language, so, and it shows in, let's see, on page 345 is where that language is. But again, it didn't change the substance of what we're doing at all. So, but it's just technically, if OAL wants us to bring it back to you guys, that's what we've got to do. So there's one other piece to this reg proposal, but there was not any modifications to it. So.
I just had a quick curiosity question.
Sure.
On the examination rescoring request, do they have to give a reason, or can they just ask and?
Really don't need
Okay.
to give a reason.
They can just hope.
Because they could have given us any reason and we would do it. They're going to pay a fee.
Okay.
So,
Just
they kind of
curious.
had a point. It just needs to be in writing was the main point.
Seems fine to me.
Do we need a motion for this one?
Yeah. It's in the memo.
All right, someone on this side of the table.
motion. I set forth the motion that we approve the proposed text and delegate to the executive. Is that right? Am I reading the right language? Somebody's pointing. Okay. The authority to adopt the proposed regulatory changes, to follow established procedures and processes in doing so, and also delegate to the executive officer the authority to make any technical or non-substantive changes that may be required in completing the rulemaking file.
Did that include the 45-day
It's already
public
been
comment
through that.
period? Oh, it's already been through that,
Right.
okay.
Yeah.
Perfect.
I'll second that.
Finish line, but not quite.
Then a second, maybe?
Second, fine.
Christina
Crystal,
did.
go ahead.
Okay.
Oh, I'll second that.
Here's the vote. Deborah Brown,
Yes.
Christina Wong,
Yes.
Dr. Leah Brew,
Yes.
Max Disposti.
Yes.
Betty Conley,
Yes.
Jonathan Maddox.
Yes.
Crystal Anthony.
Yes.
Motion carries.
I think I'm getting the hang of
You're doing good. Now 3:49.
it. Now we're on 349. All right, so this is still Christie.
It's me again. So as you know, we had a supervision committee that met for a couple of years. We had legislation that came out of it, and we've got regulations that came out of it. We had to put the regulations on hold while the legislation was being passed, and it wound up being a 2-year bill. And we've brought the regulations back to you at different points because they've sat for a few years and needed some updates. So there's some other small changes that needed to be made, so we're bringing them to you. They've actually started going through the department's initial review process, and they've identified some changes. We also identified, they're so comprehensive, we're going to be, we found some little things that needed some changes. But I think I'm going to briefly go over what the regs do and just say what the little changes are. So, we're talking about documentation required when a supervisor dies or becomes incapacitated before they've signed for the hours. We're creating consistency in our supervision requirements among the license types, requiring the supervisors to notify the board that they are supervising and meet those qualifications to supervise. We're going to require supervisors and supervisees to complete and sign a supervision agreement. We are codifying how completed experience hours must be verified to the board. Specifying requirements pertaining to temporary substitute supervisors. We're allowing continuing professional development activities to count towards supervisor ongoing training requirements, and allowing exemptions for those who hold an approved supervisor certification. Clarifying experience requirements when gained outside of California, and who can supervise experience required with couples, families, or children for LPCCs. And so the proposed amendments that we've identified, a lot of them are technical and non-substantive, or just clarifying. We're striking some language that's duplicated in statute. That we're modifying some language that specifies that the experience gained by applicants for associate registration under the 90-day rule must comply with all supervision-related requirements, because it wasn't clear in there, because we mentioned associates, but you're not really technically an associate yet if you're under the 90-day rule. And then we're updating some implementation dates for certain phased-in requirements. It was hard to know exactly when these regs would take effect, but we have a closer idea now. So it's looking like we moved them to 2021 and 2022 for different components. That will give us plenty of time to let supervisors know of the new requirements and give them time to be in compliance. So that's what we've got going on there. So I'm looking at these, we're probably at least another year out from these being implemented, maybe not even quite that long, depending on how things go through the public comment period and the final review process. They've already been through initial review at DCA, but they have not been noticed yet, and that would be the next step.
And that's before the new regulations for supervisors kick in, right? Or are implemented?
Right, so what would happen is, so say it takes another year, which I don't think it'll be quite a year, but hard to know. And so what'll happen is they'll take effect, certain pieces of it will take effect right away. And And then other pieces will be phased in, which are the ones where supervisors have to send in, something to comply with the new requirements. Or have, some major change. There's a couple of different components that have a phased-in requirement. Did I answer what you asked?
Yeah, I'm just looking at how, takes a while to get these changes enacted, I guess, and in place. But Leanne?
A couple of questions on, hopefully it wasn't the same day that I was reading before, page 353, at the very top, A, pursuant to section blah, in a setting which is not a private practice, should we add or professional corporation?
We can, under the
What does the statute say on
well,
that?
I didn't know.
under the new definitions, which are not law yet, a professional corporation is a type of private practice.
Oh, okay.
That's
So
right.
it's not
That's-
absolutely
that's
necessary. It might be nice for clarifying. I
But
mean,
you'll
yeah,
end up taking it
wouldn't-
out later because you'll say it's already defined
But it-
somewhere else, so
Yeah.
maybe that doesn't make sense. Okay, and then on page 356, toward the bottom, C2, should MFTs be in there? A supervisor who is a licensed clinical social worker, licensed psychologist, or licensed physician who is board certified in psychiatry shall have sufficient education and experience in treating couples. Is MFT missing because it's an assumption that MFTs already have that? Because this is under the LPCC stuff, isn't it?
Yes, so it's assumed that.
It's just
MFTs
assuming
already have
MFTs
it, yeah.
obviously are qualified.
Right.
Okay. And then on page 357, at the very bottom, number 4, transitioning to 358, I didn't know if cultural was added to the language that we did in the past. The supervisor shall self-monitor for and address supervision dynamics such as, but not limited to. I'm not saying that we have to put it because you did say not limited to, but culture is so important. I didn't know if that should have been added because I know that was part of other things that we discussed in the law.
It was, so that's the language we use in AB 93, which is the
Okay.
supervision bill. So
Okay.
it wasn't, we didn't use cultural there at
That
that
part,
time.
okay. Okay, and I think everything else, page 367, letter E, Roman numeral 1, or little tiny I. And it may be that this section is irrelevant for this, but we put requirements pertaining to registration as an associate as specified in section. Does trainee need to be part of this? No, okay. Okay, there were a couple of those that I saw. All right, so see, it was all on the same day. Maybe I hadn't had food yet, and that's the problem as opposed to now. Let me
Always good
just-
to have another I, though, on it.
Okay,
Because
that's
it's
it.
really easy for something to slip through.
Oh, for sure.
So it's always appreciated.
Thank you. That's it.
Are we ready to take a public?
I believe we are. Let's move into public comment. Thank you for being patient, Ben.
I didn't want to speak out of turn. So just 2 questions, and forgive me because I should probably know these, but I know it's been a journey with these to get to where it is right now. On
Sure.
page 353, letter C, there, kind of middle toward the bottom of the page. Is that language, does that suggest that the supervisor responsibility statement, that form, is going to go away? Sort of replaced by this supervision agreement?
Correct.
And then, if so, is there going to be a standardized form for that, or is that going
Yes.
to be? Okay.
Yeah, there will be a form, and the form will be based on what is listed here, where it said, the supervision agreement shall include all the following, so it'll tell you what's going to be in the form, but yes, we will provide that.
And with this language being as it is, if somebody did a supervision agreement that wasn't on that particular form, but addressed all of the items here, would that still be accepted as valid?
Yes, it would, because the form is not in our regulations. So, yes, that we would not recommend that they do it that way. It would be much harder for us to, I mean, I could see the benefit because you might want to have a more extensive supervision agreement.
Sure.
But I think for our purposes, for our staff, it's easier for them to say, oh, this meets the requirements and move on from there. But they could certainly incorporate that into a larger agreement they might want to do between the two.
That makes sense, thank you. And the other question I had is sort of related. On page, 354, letter D, talking about the logs of experience. That would at least seem to suggest that the board would accept logs that address those issues, but aren't necessarily on the board promulgated form. That could be actually a really awesome thing for people who documented experience out of state. Is that correct? I didn't know if that was intentional or not, I couldn't remember, but I thought that's a great thing either way. But am I reading that right, that you would accept a log even if it's not on the sort of state form or the BBS form?
Yes, I mean, anytime we have a form that's not in our regulation, that's not part of our regulations, then technically,
Yeah, we take it.
right?
Okay, that is good news to me, thank you.
Yeah, you're welcome.
I guess the last question I had, and it's too hard for me to filter through this, is it supposed to be, assuming everything goes smoothly at the moment, effective 2022? Is that, what's 2021 versus what's 2022?
Let me look for that really quick. So
Philosophically.
there's two pieces. There's the supervisor self-assessment report.
That's 22.
That's 22. So, and so it's, so what we're saying is licensees acting as a supervisor prior to January 1st, 2022 shall submit a self-assessment report to the board by December 31st, 2022, essentially giving them over a year to comply. But any new supervisor, of course, has to do it within 60 days, I believe, is the other, within 60 days of the commencement of supervision. Then the other component is, let's see, so that's the self-assessment report. Let me look here for that other date. This supervisor training is the other piece. So that will be effective January 1st, 2021. Licensees who commence supervision for the first time in California shall obtain 15 hours in supervision training or coursework. So that, I believe, is the other phased in, and that is going to apply to, again, those who commence supervision for the first time in California. So if you're already a supervisor, you don't have to go, and you haven't done 15 hours, because right now MFT and LCSW, or LPCCs don't have to do that. We're not going to make you go back, but if you're a new supervisor, you will have to do that. So that's the 2021.
Thank you, that's helpful, because I'd like to get the word out to people.
For sure, yeah.
One more question before we beat this to death. As I was reading this, I had in my mind, is there any need to add any language or change any language with the passage of 1651?
Oh, for LEP.
I took a look at that, and I did not see anything that.
That would
change
red
that.
flag for a change?
Correct, yeah.
And
No,
and
definitely-
nothing popped out at me either, but I
Yeah.
don't have the same lens that you do. So I thought it would be worth asking.
Sure,
So
no, worth asking.
does not appear to be
No, I
any-
did not find anything that needed to be.
Okay.
Fortunately.
Fortunately, yes. All right. So any further discussion? Then I'm going to look for a motion.
I'll make a motion to approve the proposed text for a 45-day public comment period and delegate to the executive officer the authority to adopt the proposed regulatory changes if there are no adverse comments received during the public comment period, to follow established procedures and processes in doing so, and also delegate to the executive officer the authority to make any technical or non-substantive changes that may be required in completing the rulemaking file.
I'll second that.
Okay. Christina?
Deborah Brown?
Yes.
Christina Wong,
Yes.
Dr. Leah Brew,
Yes.
Max Disposi,
Yes.
Betty Conley,
Yes.
Jonathan Maddox.
Yes.
Crystal Anthony.
Yes.
Motion carries.
Okay. Well. Okay, so we're back to Roseanne for
Yes.
regulations to implement AB 2138.
Yes, and so we're going to talk a little bit about the AB 2138 regulations, which are included as an attachment here. And also, in case anybody wants to refer to the actual text of AB 2138 during the discussion, just so you know, that can be found on page 147 of the packet. It was included as part of another bill, so I didn't include it twice. But moving forward, we are in the process of proposing regulations to implement AB 2138. At its March 1, 2019 meeting, the board approved regulatory language to implement AB 2138. Key provisions of that bill: it only permits a board to deny a license on grounds that an applicant has been convicted of a crime or been subject to formal discipline if either of two things are met. The conviction was within the 7 years of the date of the application and is substantially related to the qualifications, functions, or duties of the profession, except for the 7-year limit does not apply to convictions for a serious felony or certain sex offenses. And then also number 2, if the applicant has been subject to formal discipline by a licensing board within the past 7 years for professional misconduct that's substantially related, then the board can deny. The bill also requires each board to develop criteria to determine whether a crime is substantially related to the qualifications, functions, or duties of the profession. And it requires each board to develop criteria to evaluate rehabilitation when considering denying, suspending, or revoking a license. And a showing of rehabilitation shall be considered if the applicant has completed their criminal sentence without a violation of parole or probation, or if the board otherwise finds that the criteria for rehabilitation has been met. So we started the regulatory process. We noticed the regulation proposal on August 16th, 2019, and the 45-day public comment period was held. It ended on September 30th, 2019, and we had a hearing on that date. And we received one written letter commenting on the regulation proposal. And so in that letter, the letter was from Catherine Katcher, who's the Executive Director of Root and Rebound Reentry Advocates, and it was dated September 30th, 2019, and you can find that letter in Attachment A. And so what I've done here is I've summarized the different comments that were received in the letter. I can go over them one by one, or if you just want to discuss certain ones, we can do that. It's kind of up to you. And so generally, there's certain things in the letter raised, and then there were certain sort of things that the letter raised that we weren't sort of reiterating in regulations, but in those cases, it's already contained in the statute, so it really isn't appropriate to repeat it in regulations. So I guess I'll just open it up for discussion and see if there's any particular comment that anybody wants to discuss. I will note that they make some really good suggestions about clarifying certain things, and we will be engaging in outreach. We're working on an FAQ for the website to assist applicants who are going through this application process, the new process beginning July 1 of 2020, that should help to clarify for them, what exactly the board can and can't deny for under AB 2138 and things like that. We're trying to make the process a little clearer for them. So we will be doing that. So I guess I'll just open it up for discussion.
The language looks good to me. For clarification for me, so in the past, the board has often used 10 years of sobriety, most often, not for everybody, as evidence that they have been sober long enough to be safe. And so now it's 7 years from date of conviction, is that it?
Yes.
Okay, so they would have been sober 8 years, okay. True, they could be convicted and still using. So let's say they don't have to be sober and they aren't, and they had a .33 BAC, right? That's happened.
Yes.
And are we still able to say that it's substantial and that we don't think that somebody with a .33 blood alcohol level should be practicing without probation, or are our hands tied?
It gets into a situation on the date of the conviction,
Uh-huh.
when it occurred. If it's recent, then we have some cause.
And recent is defined as,
It's within that
Within the
7
7
year
years.
period.
And then there's an evaluation criteria that that 2138 kind of sets out, and how you evaluate rehabilitative evidence,
right,
and the nature and severity of the crime, the substantial relationship criteria, which is one of the regulations that was amended for this.
And much of the substantially related criteria was criteria we already had
okay.
in regulation.
Each one is going to be a case-by-case basis
Always.
still.
Yeah, it's, oh, good.
Always.
That's good.
Absolutely. There's no,
Yeah.
there's a lot of gray.
Yeah, okay.
Am
Thank
I
you.
correct in understanding, though, that the 7 years is the magic?
Yeah.
Yeah, so
And
that
I'll-
is different.
And that's conviction date at least, because sometimes that can be a
Right.
year out from the event.
Right.
Mhm.
I would also just note that a lot of times when people are convicted, they've done a lot of rehabilitation already inside. And so I can acknowledge this letter and see that they're really being a voice for those that are disproportionately denied jobs. And so I think that that's one of the major things with this regulation, that it does bring about more opportunity for people to be in these positions that, and I know that we've all talked about this and seen it, because I do see how people get out and they have their bachelor's degrees, and then they still have such difficulties and hurdles that they have to continue to combat once they're now previously incarcerated or whatever it may be. So I just want to acknowledge the letter, because I think that that was a great letter.
So what you have before you today is Roseanne did a great job of pulling out each comment and then responding to it, and what you have to decide, and the reasons for how she is suggesting we respond to it. There is no need to repeat things that are in statute and regulation. OAL will kick that back. It's duplicative, not necessary. So that's the bulk of a lot of the responses, if you read through them. To complete the rulemaking packet, we do need the board to make a motion eventually, after you're done discussing and everybody finishes the discussion, but we'd have to address if you're going to proceed as she's suggesting, or if you want to make any amendments to those comments.
I feel like
responses.
the responses were appropriate and they made sense to me. And of course, who wrote the letter wouldn't know all the language in the rulemaking and all that. So I think hopefully it'll give that person comfort and understanding that, oh yeah, this part is the law and that part is the whatever, yeah, the way it's structured.
So I just had one comment, or one question.
Just one question. So Roseanne, I'm sure that, when you received a letter, or the staff would have also that verbal communication, to further explain it, because I sometimes it's very hard, for people who don't understand, the details of the law, and when they, make kind of like a theoretical, or some idea, changes, then, things are in place. And I think, I wonder, do you guys do that, and maybe directly communicate with the,
This was via a letter, so we can reach out to them after the
so-
fact, but
All
we,
right.
at this point, we haven't decided, 100% what our response is. I have to take it to the board
Right, you
before I.
guys have to sign off on the
Right.
responses.
So we have to, approve the response,
Correct.
and then if that's
Right.
necessary,
Yeah.
then
I
you can
can't-
actually
I can't
explain.
respond on my own
Right.
to it. It has to be approved by the board.
Okay.
Right, and that will be included in the rulemaking packet too, so it'll all become part of the record.
So as for now, there's no change to the language?
Correct.
We just
Right.
have to, make sure that, your recommendation, we
Unless,
approve, and.
Right.
unless based on the comments, the board wants to make a change, and that's why we're here today,
Right,
to
why we're
either decide
a
that or to
conversation.
approve the responses.
Right, so it's up to you, so it depends on what the motion ends up being.
So I have a
Yeah.
question about the expungement part. This one's a little bit more puzzling to me because we see in almost every case that the conviction is expunged. We see that in everyone that comes, I think, to petition, almost everyone. I mean, in quite a range of convictions that are being expunged. And they're being expunged within as little as 2 and 3 years. So what does that do to our disciplinary guidelines?
I'm gonna let Kim answer that.
So our disciplinary guidelines are going to change. It's, the AB 2138 was the primary reason we pulled those back, because they were already in the rulemaking process, but it was rather lengthy. We hadn't even noticed the revised disciplinary guidelines that you approved a couple of years ago because of this. So once AB 2138 rules and regs all become incorporated, we will run a new disciplinary guideline package to reflect some of this, all the new revisions. And in terms of expungement, is until the law changes, we're kind of,
It's a wait and see.
it's a wait and see. And just, it's not that we didn't consider expungements before, we did. We looked at that as rehabilitative evidence, but now it's, because of the way 2138 is written, that it's, we're only permitted to review certain areas. We can't fully dive in and consider what's going on, so.
So it's not, I guess, in continuing our earlier conversation where we said, well, you still have the 7 years, that could very well change
Correct.
if there's an expungement.
Correct.
And every case is going to be, it's case-by-case basis still, depending on what you have.
Well, I just hope we keep statistics. I guess so what's before us is to respond to the letter.
Correct.
And I'm willing to make a motion. I haven't heard any problems with the letter itself. To direct staff to make any discussed changes and any non-substantive changes and complete the regulatory process.
I second that motion.
Deborah Brown?
Yes.
Christina Wong?
Yes.
Leah Brew?
Yes.
Max Disposti?
Yes.
Betty Conley?
Yes.
Jonathan Maddox?
Yes.
Crystal Anthony?
Yes.
Motion carries.
So we have a comment. I'm sorry. Did you?
Jan Lee Wong, National Association of Social Workers. I commend the staff and the board for their diligent response to the root and bound letter. As Ms. Anthony stated, these people are really, really deeply concerned and care about this population, as we all do. And they're on the side of advocacy, as you could tell, and you all are on the side of regulation, as we can tell. So it's a really good process. This is really what it's all about. So I commend all of you, and I'm happy to hear that you're going to revise the frequently asked questions and the other surrounding material. And I particularly point out that your response on comment number 5 regarding the second step in evaluating rehabilitation and looking at volunteer or charity work, furthered education, successful employment, or other activities is really, really important, because many of these people do those things, and they feel very strongly that it's evidence of their rehabilitation. So thank you very much.
Thank you.
And I'll just add to that for Jan Lee, on the FAQ, we're going to give some examples. We have to be really careful with that because it's not one size fits all, and it's not, you don't necessarily have to do all of those things, but we want to sort of get it out there, the message of, here are some examples of possible things that may or may not be applicable to your case, but here are some examples for you to see.
Okay, Roseanne, I think we're closing in. normally we would look at taking a break, but I think if we can just continue on, I think we'll be able to finish
We
this
could, yeah. we
pretty,
can power through this.
pretty shortly.
Page 445.
So we are on page 445, and Roseanne, you have an update on board-sponsored and board-monitored legislation.
Yes, we have several pretty major law changes that are coming into effect in the upcoming year. And we've been, one thing I'd like to say ahead of time, we've been working pretty hard this year on outreach. We've done a number of FAQs for a number of these bigger bills, the license portability, the LEP supervisors, AB 630. We're really trying to get the word out there, and we're going to be posting a lot of the FAQs on the website, and we've been sending them out to our MFT consortium and school groups. So hopefully that will pay off in terms of people really being in the loop on that. We have all of our legislative proposals this year were signed by the governor. The biggest one, of course, was SB 679, our license portability bill. Very happy to announce that that was signed by the governor and will be coming effective January 1st. We have a lot of people, had a lot of feedback. People are very excited. So good job, team.
When was that signed? When was that signed?
That was signed, I don't have, I have the picture of the thank you note.
But it was signed in
It was signed in
September.
Yeah.
Okay.
So that one was signed, AB 630 was signed, which is the required notice to consumers, and then, of course, our omnibus bill. A couple of other ones of note, AB 1651, which is a work of CASP, in collaboration with our other professional association groups. It will allow LEPs to serve as a supervisor to associates for up to 1,200 hours in an educationally related mental health setting. We have an FAQ for that on the website, as well as some information for LEPs on the website about supervision and what that, what the qualifications are, since they haven't been doing that, to kind of bring them into the loop of what everybody else has learned about supervision. A couple of other interesting things, SB 163, which was the health care coverage for pervasive development disorder or autism bill, sought to close some of the loopholes that insurance companies use to deny treatment for behavioral health treatment. That bill was vetoed by the governor. In his veto message, he stated that he would like to see a formal licensing scheme for behavioral health providers and encourage the legislature to pursue it. So we're likely to see a bill next year or in the upcoming years around that again. And let's see, SB 10, which was the peer support specialist certification bill, that was also vetoed by the governor. The board had a supportive amended position on that. He basically said that he's working to transform the state's behavioral health care system, and there's an opportunity coming in the future to more comprehensively include peer support services, and said that that should be considered in the future via the budget process and legislation. So probably not the last we've seen of that. And SB 425, this is a bill that was passed by the legislature for all healing arts. It requires any facilities or other entities that make arrangements for a healing arts licensee to practice to report any allegations of sexual abuse or sexual misconduct that have been made in writing by a licensee or their representative. They need to report that to the applicable state licensing board within 15 days. And that's in response to some issues with medical professionals having some issues in it not getting reported to the medical board. So that's now in place for all healing arts licensees. And so that is our legislative update. Please check our website for all of our great FAQs and pass the word to as many people as you can to check those out.
I just had a quick question on number 2, AB 1540, Holden Music Therapy.
Yes.
So could you speak a little more than what's in here?
It's
Defining music, so what does that mean?
It's a practice act. It's not regulated by a state board. It's just basically limiting, you can't call yourself a certified music therapist unless you have this specific certification.
And is music therapy considered psychotherapy in nature or no?
No, and when we looked at the bill, it had some language kind of separating that. So we had a no position on the bill. It didn't change substantially since the board considered it. It's just, it's sort of like, it's basically a title protection for that specific. Yeah.
So we probably will see more Practice Act upcoming, since the music therapy, practice, the title protection for music therapy is already accomplished.
Possibly.
So, yeah. Thank you.
Christy, you've got an update on board rulemaking proposals?
Yes, so everything in this memo except for one are ones that we've already talked about today.
Okay.
So I'll just address the one on enforcement process, which is updating the board's disciplinary guidelines. So that has been on hold because AB 2138 had passed and we have to run those regs. So at some point, we'll circle back to that. So
Got it.
otherwise, everything was covered in other parts of the meeting. So.
As discussed.
Right.
Well, and before we go any further, once again, as always, thank you to Christy and Roseanne for all the work that you've done on all of this legislative packet. It's huge.
Thank you.
Thank you. Yes, it is. I've lost myself several times just in the circling. So with that, public comment for items not on the agenda.
Thanks for all of your work on all of this, and staff, thank you very much for all your work on it. I'm responding to a text that I got asked to bring this up in public comment from Kathy. We get a lot of concerns raised. I don't know how the board can address this or the Department of Consumer Affairs, but the issue keeps coming up about coaches and unregulated people offering services, and the public doesn't know who they're dealing with. I'm not sure what I'm asking about it, but it's a concern that keeps coming up. And we hear a lot of therapists or members talk to people who've seen coaches who are not trained, who don't really have valid background, but are charging them money. And it just feels like an exploitation issue. And I'm not sure what I'm asking from you, but I was asked, Camp's going to follow up and offer some more thoughts on this topic. So other than that, thank you very much for all your hard work.
Ben Caldwell, let me just add on that issue of coaching. There was a qualitative study a few years ago. One of my former colleagues at Alliant was one of the co-authors. It's the only reason I know about this. They looked at 10, I think it was all MFTs, who had had their licenses disciplined by their various state boards, including 5 who had lost their licenses. All 10 were continuing to see clients or planning to, and the ones who were no longer licensed professionals were just doing it under the title of coach. So it's certainly a relevant issue in terms of consumer protection. 2 things on the just on the public comment side. It would be helpful if on the website, as you're working to reduce application processing times, if there could be, as there was a few years ago, sort of an update on where you are processing-wise. I understand that there's a little bit of variability that's sort of baked in there, so you don't want to create more problems than you're solving in posting information like that, but it seems like a solvable problem, and it would, it's one of the most common questions that I see and hear is where are they in terms of in terms of application processing. So if that's the kind of thing that could be once a week, posted on the website, here's where we are, that would be really helpful. And then going way back to last year, 2018, I had made the request of Steve for a data set on clinical examinees, just so researchers like me and folks from other universities could take a look, anonymized of course, but could take a look and see sort of what is correlating with exam performance and where we're seeing meaningful differences from one time frame to another on pass rates. Is there anything that we can correlate with that? Part of the reason I mentioned that is because when we were discussing the MFT clinical exam, OPES said, well, if there's a difference in pass rates, it must be because there's a difference in the examinee cohort. There's really no data to support that, but I'm also not in a place to argue with that. It would be good to really just take a look at the data and see if there is a meaningful difference in cohort there. So I'm just bringing that back as a reminder of that request. It would be good to have a data set at some point. Thank you.
I actually have a public comment. Sorry, oh, go ahead. Okay. I spoke with Kim about this, but I thought I'd put it on the record also. I've had someone request, and I think it's a good idea, to see if the board can explore allowing trainees and associates to upload their hours and create documents in an online format on the BBS website where they can put their hours in as they go, and then each week the supervisor can approve it, and it's all in a BBS sort of format. And it can be stored and kept, and it probably would accelerate and automate and make more efficient the ability for people to take their clinical exam. It would also give a venue for a fee if people 10 years from now say, oh, I've moved to Montana and I need a copy of my hours, that report could be printed out. So just a request for the board to consider.
Hello, Kenneth Edwards from CalPIC. All I could think about when you talked about a progress bar is when you order pizza from Domino's and the thing sort of, the little bar keeps moving along. So something like that on the BBS website would be great. I text one of my board members about exactly the same subject around the pass rates, and her immediate response was, well, can we divide by, gender, ethnicity, school, all of the different sort of markers, so that might be interesting to get that data set to be able to do some research. I wanted to say thank you so much for the portability bill. That's been such a great thing for LPCCs, particularly. People have been emailing left and right. Thank you so much. And especially thank you to these two that have helped me out so much, just in terms of understanding just a lot of the rules and the regs and how to apply them and the FAQs, and from what I'm hearing with the new portability bill and the application, thank you all. Appreciate it.
Thank you for your comments. And now we are looking for suggestions for future agenda items.
I have something, Betty.
I knew
I'm
you
just
did.
talking too much today.
No, I had down here, ask Leah.
I had notes. These are old notes. They're from August. So related to portability, so now that portability is here, this wouldn't be relevant for people who've been licensed for more than 2 years. But I wondered if the board could put on a future agenda allowing K-CREP accredited programs or COAMFTE accredited or whatever it is in social work, CSWE, when people come from out of states, if we would allow their degrees to count if they were accredited automatically, and then it would reduce processing times for the board. Accreditation requires an enormous amount of work for a program, so I think it shows that it matches the field. So anyway, to explore that and discuss it at a future meeting. Thank
Question,
you.
are you talking about those that are licensed less than 2 years?
Less than 2 years in another state and are applying to become an associate or not licensed. They would have to be applying to become an associate in California.
Coming out of accredited programs.
Yes.
Less than 2 years.
Thank you.
Dr. Caldwell.
So I have, forgive me, I haven't been here for a while, so some things have stacked up. So I'm sorry, I have 4. I'll try to be quick. One is in that sort of gap period between graduation and actually getting the registration number. As was mentioned earlier here, you're not really an associate yet, but you're not really a trainee anymore either. So it would be helpful to just discuss during that particular period of time, what is someone even supposed to call themselves? How is an agency supposed to label them in discussing their services? And it might also be worth discussing what the supervision requirements are at that time, because people wonder, is it more the trainee standards that apply in terms of the 5-to-1 ratio and that kind of thing, or is it the associate standards that would apply even though they're not quite an associate yet? So just some clarification on that sort of gap period between graduation and registration.
Can I address something in there? Just that in the newer supervision requirements were included associate applicants. So the supervision standards should be already clear, but as far as what to call them, we call them applicants, but for associate registration, but yeah, as to what employers call them is different.
If they're applying under the 90-day rule, they could apply on the 89th day. They're not an applicant until they apply. So what about between graduation and the day they apply?
They're not under our purview.
Well, they're not under your purview as trainees either, but there's still a title for them. It's just a question to address in a future meeting.
Yeah, right.
You know, we'll put it on an agenda for the future conversation, because
Excellent.
it's too easy to get sucked down the rabbit hole
I
of
know,
wanting to
I know.
answer.
So I'll do this.
It would be helpful to have a discussion and ideally some data on disciplinary actions since the uniform standards came into effect. This is purely anecdotal. I have no hard data to support it, but I get the impression that among those licensees and registrants who have been disciplined for a substance use violation, there seems to be an increased tendency to simply give up their license or registration rather than working their way through the entire rehabilitative process. It would be worth knowing whether that's a real change, a real difference or not. If people are increasingly just giving up their license, then it would be worth a discussion of the sort of consumer protection impact of that. So that was the second thing. The third is pretty technical. I don't know whether it needs to be an agenda item or whether it's better addressed with staff, but the California Consumer Privacy Act kicks in on January 1st. You have some requirements in terms of what CE approval bodies have to require of CE providers, and among those requirements is record retention. So I work for Simple Practice. We are a continuing education provider. We are going to be likely subject to CCPA. And in our discussions with CAMPT and our other CE approval bodies, it has come up that it's going to create a conflict in law, where if a consumer requests that their data be deleted, then we have to delete their data under CCPA, but we have to retain their data under the board's rules that filter down through the CE approval bodies. So maybe that's more technical, maybe that should be addressed with staff, but I'd like to get that addressed.
Ben, I addressed this with CAMPT about a week ago, and so
perfect.
I can send you what I sent them. There is actually a clause in the CCPA that somebody can request to have their information not sold, but if they're keeping the information to comply with the law, which for our regs, they have to keep it for 4 years, then it's permitted. So I'll send you what I sent to CAMPT.
That solves my problem, thank you.
Perfect.
And then the last one for, and again, just a future agenda, it would be, considering how often we hear about sort of the struggles of associates on the way to licensure, and that seems to be a very real concern, especially an economic concern about how expensive it is, and we're talking about raising fees and that kind of thing. It would be helpful to have better data on the associate workforce than what we have right now, in terms of where they're working, how much they're making. I know that we have some data from board surveys that have been conducted in the past, but it would be helpful to get just a clearer picture of that pre-licensed workforce. And then with that, just a massive thank you. I know I have not been here for a while, but I know that there is so much board and staff work that goes into all of this stuff, and it's really impressive to come in and see all that's been happening. It's fantastic and really, really helpful work. So thank you so much.
Welcome. So we also had one item that we probably do need to bring back that we had deferred as we started digressing into extensive conversations. I think it was around the ethics exam. Was that?
I have a couple of ideas. There's definitely a P&A agenda item.
There was a P&A agenda item?
Yeah, it's going back. That's the notice to consumers. And then there were some ideas for discussion, incorporating the exam in a graduation program, maybe giving it to them before they graduate, before the association, before they get their registration number, that
Okay.
kind of thing.
Yeah, but I had written ethics exam, but I did not write the other one that I identified, which was the notice to consumers. And that was where we started going down the rabbit hole, and we decided we needed a bigger conversation on that. All right, so any additional suggestions for future agenda items?
Can I bring up suggestions from that we've already like brought up, but do I have to bring them up here? Like
Bring it up.
Okay, so I'm looking more towards like the rehabilitation of what we require of people that are going through our process of rehabilitation, and maybe discussing how to further expand to be more culturally competent, and so adding additional items to it. I'm not sure how we do that, but do you remember us discussing?
Yeah.
Okay.
Right, so that would be any changes to our disciplinary guidelines, we'll see again when the board brings back the disciplinary guidelines, after all the 2138, everything has gone through, and, because that's another massive regulatory packet.
She's your best friend.
Yes. Just trust me, it's not over. You're going to see it plenty of times.
Wow. Well, with that, I'm going to thank our active participants and our stakeholders. Thank you very much. Thank you, board members, and we are going to move to adjournment. It is 3:25.